Okay. Put that there so I can see what's going on here. Check this out. I've been looking up writ of quo warranto. Please look into this writ, okay? Here's a case that I found. It is awesome. This shows a definite example, and this is really fuzzy sounding. Piece of crap. Anyways, this is a really good example of why you need to bring up issues against the judges when you're in front of these douchebags, okay? Why do you need to make them submit their oaths, their bond information, so on and so forth, right now, right here? Challenge jurisdiction first thing when you get there. Make them prove jurisdiction on for the record. Why do you need to do that? Because, like Carl Miller said, latches takes place. Now let's read this real quick. This is, it doesn't take too long to get to the point that I'm talking about here. It's going to show you, okay? Arthur Lee Johnson filed a petition for writ of quo warranto challenging the validity of his 1974 convictions for robbery. Johnson alleges that the state attorney, judge, elected officials who presided over his cases did not submit an oath of office as required by Article 3, Section 5B of the Florida Constitution, 1973. As a result, Johnson argues that his judgments and sentences were null and void because these elected officials lacked the authority of their office, and thus the subject matter of the court was never properly invoked. Now, that's a good argument, but did he bring it in time? Because of its increasing popularity, we write to explain why a writ of quo warranto is not a proper method to obtain post-conviction relief. Quo warranto is a common law writ used to inquire into the authority by which a public office is held or a franchise is claimed. Black's Law Dictionary 12, blah, 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 8th edition. It is properly used to challenge the power and authority of a constitutional officer. Yada, yada, yada. The Supreme Court in Griffin v. Stickler passed upon a quo warranto petition challenging a conviction and sentence, but specifically declined to express an opinion on whether quo warranto was an appropriate method to seek post-conviction relief. We believe it is not. Challenges to the authority of prosecuting attorney or presiding judge, while not commonplace, are not unknown. Did you hear that? Challenges to the authority of the prosecuting attorney or presiding judge, while not a commonplace, things that people don't very often do because they're sheep, are not unknown. In Sawyer v. State, the defendant argued that his trial was null and void because the assistant solicitor was not authorized to sign an information. This argument was first raised in a motion to vacate the judgment with the trial court, and the denial of the motion was part of the direct appeal. Now, there's a little footnote here. Let's go down to it real quick. The motion was filed after the expiration of the term of court during which Sawyer was tried and sentenced. Okay, so there's your footnote. Let's go back up. The Supreme Court concluded that the defendant waived this argument because he failed to raise it before the judgment and sentence were entered. Do you see that? Why do you need to do it right away? Why do you need to stand up for your rights immediately? Because if you don't, you waive it. Okay, silence is acquiescence. Period. Silence is equaling agreement. You agree that this court has jurisdiction with or without proof because you shut your mouth and did not challenge it. Now, the Supreme Court concluded that the defendant waived this argument because he failed to raise it before the judgment and sentence were entered. The Supreme Court stated, neither the common law nor our statutes favor the policy of a defendant in waiting until the last stage of the cause and attacking such defects by a motion in arrest of judgment, the granting of which would have the effect of unraveling the whole proceeding. You see that? You can unravel the whole entire proceeding from the get-go if you challenge jurisdiction right away. And how do you challenge jurisdiction? You show the Supreme Court rules for jurisdiction. But first of all, you want that oath and that fucking, what's it called? I have a video on it. Look at my video list and find the one where I talk about writ of quo warranto. I got one. I'm going to be filing it myself. Yeah, and then, so yeah, that's the point right there. That's my point. Is if you don't challenge jurisdiction right away, you lose your ability to do it. You lose your ability to win on appeal. Or even to attempt to overturn a judgment. You know what I mean? Do I need to go further? Do you want to read more of this? Okay. The visiting judge presided over the defendant's trial without obtaining an official assignment from the Chief Justice of the Supreme Court as required by Article 5, Section 2B of the Florida Constitution. As a result, the defendant argued that his conviction was void and sought to vacate the judgment pursuant to Florida Rule of Criminal Procedure, blah, 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 and rejecting this argument, the Supreme Court noted that the visiting judge was acting as a de facto judge and that the defendant waived this argument because he failed to object to the visiting judge presiding over his case. Again, he didn't do it at the time of. So obviously, this guy sat in the prison system, went to the legal library, and found this information and tried to overturn his shit after the fact. So, is ignorance of the law of no excuse? It seems that it is. Because here you see that the ignorance of jurisdictional challenge is beyond an excuse. They don't give a fuck whether or not they had authority in the first place. So there is another way to overturn it. You have to figure it out. But it's not by writ of quo warranto, obviously. And quo warranto should be brought up first thing. And the quo warranto means by what authority do you come here? I need proof of your oath of office. It needs to be on and for the record. I need your bond information on and for the record. And I need proof of jurisdiction on and for the record. Each and every case that ever existed speaks about jurisdiction first. And if you get a bunch of paperwork that doesn't say anything about jurisdiction, then you are, you better fucking start challenging that shit. You better see proof of jurisdiction over you first thing in their documents. That should be the first thing in a prosecutor's brief, is proof of jurisdiction over the person and the subject matter of the so on and so forth. So because they are applying statutes and codes, they have to prove they have jurisdiction over you. You, as an unenfranchised common law free man, not an employee of the state or federal government, i.e., read Article 5 to your Bill of Rights. It says it right there. No person shall be held for a capital or otherwise infamous crime except on a presentment or indictment of a grand jury, or if they are in, I got it right here somewhere. Let's see. It should be in here. Where's the Fifth Amendment? Oh, wait. No, not this one. Hang on. Bear with me here. I wasn't prepared. I just go with the flow on this shit. Okay, the Fifth Amendment. Bill of Rights. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces, you are military, except you are military, or in the militia, when in actual service in time of war or public danger. Do you get that? They are treating you like a military officer. You gave them the state ID, and they said, oh, look, we got an officer right here. Let's take his ass in. He's in violation of our code. Let's take him to the magistrate. Okay? This is military court, people. They have mixed venues. You belong in common law court. Whether you have ID or not, were you getting paid to do a government operation? Were you operating, for the corporation? Am I just confusing you? Or am I confusing myself? I don't know. You know what I'm saying? Do you get it? Okay, so challenge jurisdiction first thing. Require that the judge bring oath of office and his God damn it, his surety bond, his insurance bond. Make sure if he's going to go ahead and ignore the Constitution, he better fucking pay for it, because that motherfucker. I watched a video of a Australian guy, and he was doing this too. He was demanding that the judge bring his oath of office and his surety bond on and for the record, and he requested it like 6 months prior to this recording or something like that. I don't remember. It was they had more than enough time to provide this information, and the judge said, "Well, we're going to move forward." And he said, "How dare you move forward? You do not move forward. You do not have authority to move forward. How dare you? How dare you? How dare you? You do not provide your oath or your bond information. You do not have authority here." And he just stayed on topic. That is the problem. And it shut that judge up every time. And the judge is like, "Oh, well, we're going to have another case." And he said, "No, you're not going to have another case. You need to address the issue at hand now. Where is your oath? Where is your bond? Bring it now. Otherwise, you have absolutely no authority," which means you have no jurisdiction. He didn't say it like I say it, but you know what I mean? Man, you got to check it out. I don't remember where that video is, but holy shit, man. We are on fire up in this bitch. Fuck these motherfuckers. These treasonous douchebags. Yeah, I fixed it. I'm serious, man. Let's go. Fuck these assholes.